Lordship, may I be permitted to mention a matter not in the list? There is a public interest litigation, Lordship, is pending before the Honorable Court. It pertains to the electricity crisis being faced in these islands, manner. When this particular public interest litigation was filed, we were having a power shortage or disruption for about 7 to 8 hours in a day, my lord, for the municipal area, my lord. Now, after filing of this writ petition, certain directions were given. Instead of things improving, my lord, my brothers are all here.
Has deteriorated.
Has deteriorated. Now, things have come to such a situation that there is a power disruption for about 12 hours. The entire bar, the people, every year, the staff, everybody.
Even we have found that.
Now, what has actually happened, my lord, is that, my lord, I'm just praying that this may be listened so that some directions can be given. So recently, my lord, what has happened is that these power generations through diesel generators, my lord. So there are various tenders, my lord. So there was one tender where one particular agency was generating 5 megawatts of power, my lord. Now that tender, my lord, was supposed to come to an end by end of July, my lord. So in the process, the administration, my lord, floated a tender for supplying of generators for generating power to the extent of 10 megawatts instead of 5, 10. When we filed this writ petition, my lord, there was a shortage of about 15 megawatts, my lord. The demand was 50 megawatts, generation was about 35. Shortage of 15 megawatts. My lord, the administration, though it's a policy decision and administrative affair, but that has to be in conformance with the life to livelihood of the person, my lord. He cannot be made to suffer, my lord. Now, if the administration was contemplating, my lord, to award a fresh tender to somebody during the intervening period, till that fresh tender was finalized or the generators were installed, this particular agency who was generating power, at least to the extent of 5 megawatt, my lord, that tender should have been extended, my lord. A proposal was mooted, my lord, by the department. It went to the Honorable Lieutenant Governor, my lord. He refused to extend. Now it has come in the newspapers, my lord. This is going to take about 3 to 4 months to improve the situations. Now, when they say 3 to 4 months, let's take it, my lord. It's not going to happen in 3 to 4 months. It will definitely take 6 to 7 months, my lord. So let this matters be listed, my lord, tomorrow, so that some directions can be issued, my lord. Let a responsible officer.
Have you served the others?
I will do it, my lord, in the course of the day. But Rakesh is there, my lord. Let a senior officer from the administration, my lord, be here to appraise this honorable court, my lord.
Because we need to know why this is happening. A report in writing needs to be. Report in writing has to be.
Actually, my lord, this matter was supposed to be in the list today, my lord, but I think by mistake it has not come. If you see the last order, my lord.
Oh, this is actually a hearing matter. So we have decided not to take up hearing matters.
In view of the urgency, my lord, can we take it up in the list?
Let it appear tomorrow as to be mentioned. Let us see.
And let them come with a small, what is the position and what steps they are taking.
We would need to know what is
the
actually.
Students are suffering, the patients are suffering, the industry is suffering, everybody is suffering.
We understand.
And these, my lord, one more thing, my lord, these powers, my lord, I am constrained to make these submissions, my lord. There are various radials, my lord, radial 1, radial 2, radial 3, which takes power to one sectors, my lord. There is a radial called radial 1, my lord. So this radial 1, my lord, this supplies powers to Rajneval, to Chief Secretary, to the DGP, to all senior officers.
There is no interruption in.
There is no interruption. There is no interruption. And they have generators installed in their premises. There is no interruption. So they will not feel the pain. Unless the court intervenes, my lord, the islanders are going to suffer.
Absolutely. Please come back tomorrow. Let us see. Tomorrow has to be mentioned.
Bye.
May it please your lordships. My lords, may I seek your lordships?
You are the responsible. Yes.
The department is.
My lords, I wanted to make a mention, my lord, before your lordship started the day. May I, my lord?
Yes, you are not clearly audible, sir.
My lord, may I make a mention, my lord? I wanted to make a mention before your lordship started the day.
Yes.
My lord, I am making a mention to my lord Justice Ghosh. My lord, your lordships have heard one matter of, my lord, illegal arrest in PMLA. It was part heard in, my lord, Calcutta. Your lordships had kept it for 6th August, but since, my lord, your lordships are in circuit bench now. So, my lord, the matter is. So, my lord, I only wanted a date, my lord, so that your lordships could give me a date. I am told, my lord, that this your lordships could entertain.
Sitting here, not the diary there. I cannot. I am so sorry. When I
All right, no, it's
mentioned,
please,
or
please,
if
your lordship.
it is more urgent, you can make, I think some bench is in charge of, the-
No, my lord, it's already heard. I'll wait, my lord, till your lordships come. I'll make a mention again. Grateful, my lord.
after I read,
Grateful.
and I'm so sorry, from
Please,
here,
please. No, my lord, it's all right. I fully understand, my lord. Very grateful, my lord. Please, your lord.
mention after I join.
Please, my lord.
This matter, here Council Satadu Chakrani is to appear, my lord, because his tenure has not been extended. He's been under process, my lord, so he's not able to appear today. Next,
This is my consecutive visit for Blair. Second, my client manager, he's a applicant, one respondent manager. He has to on the council coming with manager and then the litigation manager. This is a consecutive time of taking time.
This issue, this cannot be overlooked.
Which issue?
previous week he was there, as my lord also knows, my lord.
The entire process are there, Mallet. So the
Mr. Chakraborty's appointment has not been extended. So he will not be able to appear unless it is extended by the authorities, right?
well, yes, I understand that. I understand that.
That's a technical issue, but then it has to be taken into consideration.
Yes, Mallet.
Next circuit. On prayer of the petitioner, the matter be, I'm not recording what
Yes,
you
yes.
said. The matter be placed before the next available circuit. On my behalf, I have a suggestion. Why don't you get in touch with Mr. Kumar before you come for the
Mallet,
hearing?
on the last occasion, I had a candid conversation with Mr. Chakraborty and he concedes on my proposal. These 2 times I am unable to, because the extension clause was going on. Then after he gave my confidence, I came, Mallet.
There,
Valid.
suggestion.
No, it is right, Mallet. Because the last understood the becoming the my part, Mallet. So I, as you lost.
Next.
Item number 2, WBC 17 of 925. But I'm appearing to the respondent.
Lord, here, my lord,
Yes.
this clarification with regard to the scale of pay, my lord. There are still some doubts, my lord. I require, my lord, let it be in the next circuit so that I can, because, my lord, I have got the chart and all. on
Oh,
the
this is that fitter.
Yes, yes, my lord. Now also there is some confusion, my lord. So I pray, my lord,
Very good.
so that I can assist the crowd properly.
You are the petitioner, right?
I am
On,
the petitioner.
on prayer of the petitioner? The matter be placed before the next available circuit.
Blair. Item number 3, session 6 of 925 with can 1 and can 2.
Your Lordship, this has to be placed in the next circuit, Your Lordship, it's incomplete. And there is a delay also.
This is section 5.
Yes, section 5 is there, so I can't argue also order 41.
Since service upon the respondents is not complete, comma, the matter be placed before the next available circuit.
Item number 4, F87 of 925.
Milord,
Extends.
Milord, I am for the respondent plaintiff in this matter, Milord. Milord, you have
Petition.
filed,
For the apparent not along with this senior from Satara Chakravarti. Next circuit, not because we have set speed post. If my brother can pick, what the.
The
no,
union,
we have not been served. We have not been served yet.
You have already sent my lord through speed post.
you've not received a copy?
No, no, Milord. We have not. Though caveat is filed, but we have not received.
He's not ready with the affidavits also. So please come back before the next circuit. Since
Grateful.
service of the respondents is not complete, comma, the matter be placed before the next available circuit.
Grateful. Grateful.
Next.
Grateful.
Your Lordship, in this matter, Mr. K.B. Jayapal for the appealant, my lord. I pray for short pass or maybe, my lord.
Have you served? Who is appealing for the respondents? Where is your service? Yes, they were appearing. A report was called for. No one for the respondents. None appears for the respondents. No accommodation is sought. In view of the above, comma, the matter be placed before the next available circuit bench.
Let it be tomorrow.
They're not there. Next.
Item number 6, negative 38 of 125.
No one.
Your lordship, not today, your lordship.
Service.
No.
And we would like to see them. There is Miss Bobita Das. She's appearing in all these matters. Oh, this is that special officer, madam. Where is that?
Yes, yes.
Is Miss Bob, you are appearing, yes. We prima facie found that there is no difficulty with the order.
But I have one problem with regard to the impugn. Lord, kindly see. The point is, Lordship, patience.
Yes, yes.
No, my apprehension is,
In addition, the petitioner's, the appellant's representative will also be there.
no, to that extent, I have no problem. Even to that extent, I have no problem. The problem lies there, Lord, to render necessary assistance to the learned special officer. Because the impugned order which the Tahsildar have passed is assailed before the writ court. On certain recognized legal ground, I have challenged the order. Now, this is creating a problem, rather, Lordship, because there is every possible.
Just go through the second paragraph of that page, second page of.
May I please note? Having heard, having regard to the controversies involved in the matter, I appoint Ms. Shipra Mandal, an advocate of this court as special officer. The special officer with the assistance of qualified surveyor. Just one
Yes.
second. Shall I conduct?
Private also she can speak or it's her choice.
Madam is taking my pain. Then I have nothing to say. Madam is taking my pain. She wants to argue my case. She wants to defend my appeal.
Please,
Well,
please.
may I? Lordship, the special officer with the assistance of qualified surveyor shall conduct an inspection in presence of all consent to ascertain whether the petitioner has encroached any part of survey number 1069. No problem, Lord. The last one, let the inspection be conducted on 2nd August 2025. No separate notice shall be issued by the special officer. To that extent also, I have no problem. These concerned Tahsildar or his representative shall remain present at the site. Perfect, Lord. And render necessary assistance to the learned special officer. This creates an apprehension in my mind because the decision which has been challenged before the writ court is of Tahsildar concern, where I've been held to be a squatter of this survey number 1069. So if he render assistance, means obviously with records he would render assistance, Lordship. He simply can't say anything, Lordship. Then again, Lordship, it would have some.
Without the records, the special officer will not be in a position to, and if the records are challenged, the writ court will deal with
I have
it.
challenged it before the writ court,
The
Lordship.
writ court will deal with it. We do not find. We do not find any difficulty.
I failed in my persuasion in that matter. Then I'm no, so my apprehension, kindly appreciate. The entire writ petition, the grounds raised, everything would get evaporated, Lordship.
Yeah, sorry, sir.
No, my lord. But that date needs to be notified again because it's for 2nd August. The work-
Yes,
yes,
yes.
that needs to be extended.
The appellant is aggrieved by the portion of the order passed by the learned single bench on July 8, 2025. Directing the Tehsildar to render necessary assistance to the learned special officer in conducting the inspection as directed. Stop. The appellant accedes to the remaining portion of the paragraph. Heard learned counsels for the parties. Paragraph, the operative portion of the order is required to be set out within having regard to the controversy from there till rupees 35,000 to be paid by the petitioner. Paragraph. The appellant has challenged an order passed by the Tehsildar, Sri Vijayapuram on February 21, 2025, directing him to vacate or remove the alleged unauthorized occupation upon government revenue land being survey number 1069 at Jangli Ghat village. The appellant complained that joint inspection was conducted without serving any prior notice to him. And copy of the inspection report was also not served upon him. The learned single judge has appointed a special officer who shall conduct an inspection in presence of all concerned with the assistance of a qualified surveyor. The Tehsildar has been directed to remain present. Tehsildar or his representative has been directed to remain present at the site and render necessary assistance to the learned special officer. Paragraph in R considered view, rendering necessary assistance to the special officer would indicate that the Tehsildar shall provide documents that may be asked for by the special officer to assist him in the inspection. Such direction can, under no circumstances, be said to be detrimental to the interest of the appellant. Since the appellant has been permitted to remain present during the inspection, he shall be at liberty to place his contention before the special officer at the relevant time, and assistance of the Tehsildar shall not cause any prejudice to him. Paragraph. In view of the above, this court is, in view of the above, this court is inclined to hold that the application being, the appeal being MAT 38 of 2025 is devoid of merits and is liable to be dismissed. Paragraph. Accordingly, the appeal is dismissed. The order passed by the learned single bench, the order impugned passed by the learned single bench on July 8, 2025 is affirmed. Paragraph. Since the date of inspection was fixed on 2nd August 2025, the special officer is requested to fix another date for holding such inspection and serve notice upon all concerned, including the parties hearing, with regard to the same.
But the interim order which was conferred to me for a period of 6 weeks, my order needs to be extended for further period, Lordship. Because inspection done, its report would be submitted to read court. I have it.
The interim order granted earlier be extended till 31st August 2025 or until further orders, whichever is it.
I'm great.
Urgency report. Since no affidavit and urgency report also, both.
Item number 7, MAT 39 of 25, cannot 2 and 3.
Yesterday, this was posted to next circuit because
did
I
it?
filed a can for reception of additional evidence.
Oh,
So everything can be taken.
How did this come here? Come up line applications are there.
सब एक साथ
Please see the earlier order.
leave
Huh?
So,
No,
exception
order
of-
passed.
no. Exception
This one, no order need be passed. He didn't. So please be careful. Please be careful. Yes.
Lordship, I am for the.
So we can deal with the matter?
I pray for short pass over your lordship.
My lord, he has no role to play because the allegation is against respondent number 1.
Short matter?
My lord, injunction order was passed by the trial court. Subsequently, despite of injunction order, the other party was merely carrying construction 3 and 4. I filed an 151 application. The court directed the SHO to see that the order of the court shall not be floated.
That has not been done.
That has not been done. Subsequently, once again, for some period, the work was stalled. Again started, we issued notice. Then also nothing was done. We again took out an application. The court again directed, my lord. Despite of that, work was going on. That compel us to approach this honorable court, my lord. Now, my lord, a suit was filed, my
Who
lord.
is the authority? A report needs to be called.
Authority, my lord, SHO.
For the respondent 1 SHO concern. 151.
Who is the troubleshooter, my lord?
Concern. Prima facie, I have taken some instruction that on 30th July 2025, revenue officer was called by the SHO because there was a direct order. So revenue officer was called to the SHO and visited the spot. On the basis of the statement of the Patori concern, that the suit property, in the suit property, there is no ongoing construction work. That is the difficulty. Time of visit, I have taken, I talked with the SHO.
You need to submit a report to the.
Lordship.
That is,
Lordship.
that amounts to violation of the court's order, right?
Lordship.
Where is the last order in can you please show me?
My lord, of the court, my lord, of the.
The one which is challenged here.
No, I have not challenged. I say that despite of repeated orders of the court, the SHO is sitting tight over the matter. My lord, if my lord, since my lord is asking for a report, I did not want to waste the time of the court. But if my lord sees there are repeated 3 orders by the trial court, first injunction and thereafter 2 orders directing the SHO.
Orders, please show me.
My lord, my lord may kindly see page 38, my lord. After
What is
the,
the exact direction of the.
my lord, injunction order is at page 27, my lord. Relevant would be page 28.
This is not the order. This is an application sent. Where is
And
the
at
order?
page 28, my lord.
28 is an application. Or 27 is the.
I'm sorry, my lord.
11th April order,
My lord.
27.
Relevant is page 28, my lord.
A status quo order was
My
there
lord.
in respect of nature, character and possession.
My lord. The suit is, my lord, for recovery of possession. They saying it is my land. Now the submission which has been advanced by the other side say that in the suit land no work is going on. It is the case they are residing in the suit land. Now, my lord, we come to page 38. First order on an application filed by me under section 151. This is of 25th of April.
Which is matching, it's 37 here. 25th April order, right?
My lord, I'm sorry, my lord.
25th.
It's page 37.
My lord. My lord, thereafter, once again, page 52 or 53, my lord. My lord, may kindly have a look. Last order of 11 July.
11 July 52.
My lord.
There should be a report on record.
My lord, I enclose the photo. What I am on, my lord, subject to what comments to my lords. My lord, they are saying construction is in some other property. They are saying, though that cannot be because it is their suit. It is not my suit, my lord. So I let me submit it till such time no construction, my lord. No,
Construction, so how?
no, he's not saying no construction. He's saying that not in the suit property. My lord, can you see photographs, my lord? Last annexure.
are neither here nor
My
there.
lord. What has been fallen from my learned friend? My learned friend says that construction is not in the suit property. But rest I leave to this honorable
No,
court.
the
My
defendant in the,
lord, I took out an injunction application, my lord. Now, my lord, repeated orders were passed by the court and the orders of the courts were floated, my lord.
why didn't you avail of order 39 rule 2A?
My lord, it's a separate proceeding. It will take another 1 week. That time construction will be over.
Lordship, I am the plaintiff, Lordship. Allegation is against me. Lordship, may I clarify that I don't have any objection to grant injunction in respect of suit property because part of the suit property is encroached by the defendants. I don't have any objection. I also agree to grant injunction. Kindly have a look, Lordship. There are two set of property adjacent to each other. Suit property is 51, Lordship, and my recorded land is 55/1. I am making by 1 till 51. So I don't have an objection to grant injunction in respect of shoot land. Now they're trying to interfere in my recorded land that is 55/1, which is adjacent to the shoot land.
You say that 51 is also your land.
Yes, it is recorded.
Here.
It is recorded. It is recorded. And they have encroached. I don't have any objection with respect to shoot land. But I am making construction 55/1 and they are interfering with my recorded land.
My lord,
By
in
ego.
spite of opportunity, no written objection filed. This submission which my learned friend is advancing, this is advancing first time before this court. There was an injunction, hearing was done, and on the basis of it is a contested order, my lord. And my learned friend
So
today,
since the suit property is 51.
yes,
51, Lordship.
Objection to
No objection, Lordship.
yes,
And
he
he's
is carrying construction in 51.
No, no.
for that a survey cost commission.
My lord,
Yes.
that's why I am saying, my lord.
Lordship. Yes.
That has to be done before the trial court.
My lord, and the trial court, my lord, since they were saying that they will file, let them file a report after inspection, but still such time, because what has been advanced by my learned friend, that is not the ground taken in the injunction application. If my lord sees the order at page 27, that was not the ground which my learned friend is taking today.
You say that there is construction in 51, he says there is no construction in
Yes.
51. So, and his construction is in 55/1.
Now he's saying that is not the ground trial court in the injunction.
Case. It is not the case.
My lord,
Trial court is concerned.
Lordship.
but they have to file a written objection stating that we have not.
Yes, because he has no objection to the suit property.
Lordship.
That's
My lord.
why he doesn't
My
need to
lord.
come back with a written
But
objection.
our contention is that the construction has been carried.
An application under Order 26 Rule 9.
Lordship.
But my lord, there is an injunction order.
It's a boundary dispute or a land dispute, there has to be a survey to ascertain whether this is 51 or 55.
My lord, that's why in the last order, the court has said the Tahsildar to assist.
Yes, this is at my request. At my request.
State, proceed to the, visited to the place of, place.
Verifying the boundaries and nature of suit property as per revenue records, all that is done.
No, it was not done, my lord.
It was done,
Yes.
but as per I have taken this.
Please come back with a report
Yes.
Lots,
to show that you have complied with this order.
lots.
Lordship, my respectful submission, since the case is pending before the civil court, Lordship is absolutely right. Since there is a provision order 39, rule 7 for local inspection commissioner to be appointed.
Sir, it is not 26 Rule 9, it has to be a local.
Lordship. And second set of argument, Lordship, since there is a provision for violation of the injunction order, since it is a violation.
Same time,
Yes.
this will also can be filed.
So this submission, Lordship, this will be considered. So the civil court has jurisdiction to decide what is the 39 rule 2A. They did take opt of that provision.
Even without that,
Lordship.
they can
Lordship.
reach,
Lordship.
this court, isn't it?
Lordship.
The two options for you were, one is order 39 rule 2A or a misappeal. You have not done any of them.
Lordship.
You have directly come up before this.
Look, since I have taken out an application under 151, because we are sure that this is the property. We took out an application, court said, you see that the status quo order passed by the court shall not be flouted. Despite of that, my lord, I am against the arbitrary act on the part of the station house officer, who in one or way or another is supporting the private party, my lord.
I understand, but you have come up directly in a writ petition without approaching the first court.
But my lord, my grievances is that there are orders of the court which are not complied, my lord. In a writ jurisdiction, definitely, my lord, I can ask for, because the state authorities are under legal obligation to act.
But it will help you. I'm not saying that it's not maintainable. I have my doubts as to how far this will help you. You need require a survey.
My lord.
Let let him come back with the report, let's see. The petitioner.
Report from Tahsildar also. Lordship, it is very helpful for adjudication because they are the proper person.
The Tahsildar and the station house officer both.
Lordship.
Let both
Lordship,
come with the report.
They are the
That this order is being complied with,
Lordship.
right? The petitioners who are the defendants in a, it's a title suit.
Lordship, recovery of possession.
Civil
Title
suit
suit.
filed by the
Recovery of possession based on title.
plaintiff slash private respondents filed an injunction application before the learned trial court. Seeking a direction restraining the plaintiffs therein from carrying out any construction work in the suit property. By an order passed on April 11, 2025, the learned trial court directed both the parties to maintain status quo in respect of the nature, character and possession in respect of the property as on that date. The private respondents slash plaintiffs continued to raise construction in the property despite such order, for which an application was filed by the present petitioners under section 151 of the Code of Civil Procedure. Stopped by an order passed on 25th April 2025, the learned trial court allowed the application and directed the SHO, PS Aberdeen to look into the matter so that the order of the court dated April 11, 2025 was complied with by both the parties. According to the petitioners, the construction continued, for which the petitioners again approached the learned trial court. And by an order passed on July 11, 2025, the SHO was directed to take all necessary steps, including visiting the suit property, to ascertain if any construction or alteration work was being carried out therein by the plaintiffs in violation of the status quo order. Stop. In the event of such violation, the SHO was directed to immediately take appropriate lawful action to stop such activity and ensure that no construction slash alteration work was done on the suit land. Stop. The Tahsildar, Port Blair was directed to provide necessary assistance to the PS Aberdeen in verifying the boundaries and nature of the suit property as per the revenue records. With the assistance of the police, if necessary, for effective implementation of the order as well as the earlier order of status quo. Paragraph. Learned counsel for the petitioners submits that construction is still going on in the suit land. Paragraph. Learned counsel for the private respondents slash plaintiffs submits that the suit property pertains to survey number 51, whereas the construction is going on in the property of, in the land of the private respondents in survey number 55/1. Learned counsel for the official respondents seeks to submit a report demonstrating compliance of the orders passed by the learned trial court. Day after tomorrow? Friday? Yes. Such report be submitted on the adjourned date. Paragraph, let the matter appear under the same heading on 8th. Next.
Number 2, WPS number 35.
Lordship, I have responded. On this day, I filed my Rogan. I am paying for the petition, Your Lordship.
You're ready for the hearing?
Lordship, I am filing my PO, Lordship.
You want to file
Lordship,
it?
the issue herein is regard to issuance of transfer certificate in favor of the minor.
So why do you want to file an opposition?
Lordship, in this matter, the husband has filed an guardianship case. The wife has filed a maintenance case. The husband also wants to file a case for restoration of conjugal rights. The husband wants to live with his wife. But I pray, Lordship, can this matter be sent to mediation? And if this.
The Lordship, the minor herein has got admitted to a new school. She is not being allowed to continue her studies only because of the reason that the earlier school is not issuing transfer certificate. So this does not have any relation to the matrimonial dispute.
Definitely, Lordship, because.
The child
There
has
is
to be considered.
dispute pending.
Lordship, the husband happens to be a resident of Rangat, Middle and
There is
Awan.
no suit filed as yet, right?
No,
Is there any matrimonial suit pending?
no.
No.
The husband.
So why
Pending. There is a suit. There is one miss case that has been filed.
By the
miss
wife.
Case has been filed by the wife, and the husband has filed a case for guardianship as well. But that has just that is in the initial stage. In the stage of
pending
service of
before
the
the civil court, right?
Family
pending
court,
before the family court, but there is no stay to that effect.
Since it's pending before the family court, this court cannot send it for mediation.
No,
You have to apply before the family court for mediation.
Lordship, I understand. But Lordship, what I pray, Lordship, the husband wants to live with his wife. Yeah.
The school has to issue a transfer certificate. Why isn't the school? You are appearing for the school.
No, Lordship, I am for husband, Lordship. For school.
You served the school.
I have served, Your Lordship.
Where is your
Prima
affidavit
facie
of
service
service?
appearing, affidavit of service is already there on.
Because the principal respondent is the school, right?
Lord, I will be appearing for the school.
Yes.
My submission is that this is a private school and rate is not maintainable.
Private school.
Yes.
Your Lordship, even though if it is a private school, Your Lordship.
How is the rate maintainable?
Your Lordship, issuance of transfer certificate is something which is a fundamental right, Your Lordship.
Go to civil court.
I would like to take instruction from this thing. Let this be fixed tomorrow, Your Lordship. Let this be fixed tomorrow.
Next circuit.
Tomorrow, Your Lordship. Because there is an urgency here, Your Lordship. There is an urgency, so I
You
pray.
first satisfy the maintainability issue.
I am satisfied tomorrow, Your
It's a private dispute.
Lordship.
Right.
Learned counsel for the first respondent submits that the writ is not maintainable since the first respondent is a private school and the dispute between the parties has no public element. Paragraph. Learned counsel for the petitioner seeks accommodation to take necessary instructions. Paragraph, let the matter appear under the same heading on 7 tomorrow.
Lordship.
Please take instructions. You can withdraw and approach the appropriate.
Your Lordship, I'll take necessary instructions.
Next.
Number 3, WPS 365.
Prayer is innocuous, Lord. Lord, what has happened, the writ petitioners, being husband-wife, by virtue of adoption deed, took a child on adoption. The biological father have given the child, yes, deed is there. Lord, in the birth certificate, the name of the biological parents stands recorded. We want to get our name replaced. We approached the authorities. Lord, I have brought the.
It is included in the adoption order. It's not included in the adoption order.
Lord,
That the names of the adoptive parents be recorded.
but that thing, the authority is saying that I need to get an order from court. No decision has been taken.
That's what I'm asking. It's
Well,
not in the adoption order.
Everything is there, Lord. Everything is there. Lord,
just because,
Have you served the registrar?
yes, yes, for whom, madam?
But appearing
Yes.
registrar, yes, yesterday she was not appearing for the registrar.
The registrar has been served.
Wanted to come back today for that.
But I am told by Babita madam today morning that she would appear for respondent number 2 also.
Two also.
She just let it be passed,
passed
passed
on.
on. Let her,
be
let her
passed on.
come, let her come, let her. बोले सुबह बोली joint में हम भी appear होंगे.
Item number 4, WPA 356 of 925.
My lord, in this matter for the writ petition, senior advocate, the matter was listed today, my lord. We have been directed by this honorable court to serve the copy upon the respondent. We have
You've
served.
served?
Yes.
Is anyone appearing?
My lord, I may be directed, my lord, and I would like to have a leave, my lord, that I have not filed this before the registry, but it is ready. During the course of the day, I'll file. It has been served.
Is it served? Begin. Served? Let it be tomorrow. On prayer of the petitioner, the matter is served the day. Who appeals for the passing order? Normally,
Miss Babita Das is appearing.
in this matter?
No, Your Honor, I did not get the copy, Your Honor, writ petition copy. If they will supply, then. in the
Please give her a copy in course of this day so that I can take up the matter. It's a very short issue.
Yes, my lord. I'll also file something.
Please file the executive of service before the registry and give her a copy.
Yes, my lord.
Item number 5, WPA 378 of 925.
Your Lordship, Miss Babita Das is appearing for respondent.
Short issues involved. The issue is that, my lord, the petitioner is a joint record tenant of the land. Which is annexed page number 18. The record of holding register. It shows the name of the petitioner is there.
18, 1
1
Yes.
And next is the sale deed by virtue of the sale deed. Page number 18, my lord.
Petitioner is Syed Mehboob Ali.
Yes, 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 yes. The second name is Syed
Second,
Mehboob.
yes.
Number 2, joint record tenant. It is a purchase of property plus sale deed, page number 19. Thereafter, my lord, this petitioner approached the deputy commissioner for subdivision of the land at page number 29. He made application along with the proposed map how it is subdivided. It is submitted, and thereafter the deputy commissioner registered a review case at page number 30. Issued a notice to appear before him, but it has not been taken to logical conclusion. It is pending before the deputy commissioner. So direction be issued to deputy commissioner to dispose my subdivision case. It was applied during December 24.
Yes, please dispose of this application.
That's
This,
all. This is my only prayer.
for subdivision.
They have received the copy, Your Honor. I have take the instruction, Your Honor, for
What instruction do you want?
to my senior, Your Honor, to dispose of nonsense like.
A very innocuous prayer, let it be disposed of. Or let it be passed over.
Passed
There is another matter which is passed over.
Yes.
Please wait for some time.
Okay.
Pass it.
Item number 6, WPA 379 of 925.
Yes, who is appearing? No one. None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. Huh? Petition. Yes, next.
Item number 7, WPA 384 of 925.
My lord, in this matter for the writ petitioner and the senior petitioner, my lord, the members on fill the promise which multiple course was its departure in the matter in a back tax matter. This is the order.
Yes, yes.
My lord, in this
It's
matter.
the same matter.
Yes, my lord. And the same date of petition forward, on 22nd of July.
I appears for the response.
The same order be passed?
This matter pertains to same.
Same issue, yes. The same order. There's a direction for affidavit.
Yes.
This order. Several orders have been passed earlier also. Next.
Item number 8. Passbook PS 385 of 2025.
Same issue. Sir. Same issue.
Who is appearing? Same issue. Same order, no? Same order, same issue.
Item number 9.
Lord,
Passbook PS 177 of
This
2025.
Mrs. Sadhu Chakravarti will appear in this. Mrs. Sadhu Chakravarti will appear because I was one of the union was, I was earlier to be as a part of the union, so I cannot do
You
it.
cannot do it.
So that's why difficulty, my lord. Let it be next circuit, my lord. I tell the department to make some another arrangement if what is necessary.
One thing, my lord, I would submit, my lord,
Yes.
because this writ petition is pertaining to a contract between the seaman and the Andaman Nicobar administration. Honorable Lieutenant Governor had constituted a committee and directed, a proposal was made, everything was finalized. Because here are difficulties that since 2012, the said
No revision of wages.
no revision was, for that same reason, a draft memorandum was published, but subsequently it was not published. So we had preferred the writ petition. Honorable High Court on the first date itself had specifically directed them to file an affidavit pertaining to what is the status at your stage. And the administration has filed their affidavit also. It is with the record, my lord. That may be seen once, my lord, because.
They are not contesting at all.
Yes, my lord, but
They are not in a position to contest.
So I am not in a position to appear.
but an interim at least.
So I think you need to serve the respondents. Why
Yes,
don't
ma'am,
you
we have-
receive the copy if you're not in a position?
Lord, earlier I intimated, my lord, but that is a difficulty. Lord, I write a letter to the authorities to make necessary arrangements for this matter.
We have received and filed an affidavit to that extent also.
Now, file
But they cannot because how can they appear
Right
from
now.
both the sides?
Yes, yes, Lord, that is a
Right now,
It should not be other against the
Just
professional.
serve a notice upon the and I'll record that they are not represented.
my,
Since the respondents are not represented, comma, the petitioners are directed to serve notice upon the respondents indicating pendency of the writ application. Paragraph, the matter be placed before the next available circuit bench.
okay.
Problem.
Mr. Kumar, I'll request you to.
Yes, yes, I also
be-
communicate, my lord.
There is someone.
Yes, yes, absolutely right.
Item number 10.
Lord, I'm for.
Passbook PS 209 of 2025.
Mother in this matter, Mrs. Miller, the respondent number 3. My lord, she is in these before Supreme Court, my lord. After this question.
Lord, I'm for the respondent number 1 and 2, my lord. This is that matter, my lord. I have apprised that demolition order has been passed. Subsequently, the file was processed to the chairman for approval for execution. The petitioner want an execution of the demolition order. They said they prefer an appeal on last occasion. They said prefer an appeal against an order passed by the board.
Your Lordship, I am appearing, Your Lordship, through video conference, Your Lordship. Your Lordship, we have already preferred an appeal along with the application for condonation of delay.
You are the private respondent, right?
Yes, Your Lordship, I am for the private respondent.
You are the petitioner.
So the implementation which I have sought is at page 21. Because it's an order of demolition dated. After I filed the petition,
The appeal has been concluded.
while after 7 years, incomplete appeal. In the opposition, they say no, that this order was not communicated to private respondent. If that be the case, if not since the very memo of appeal, which they have filed before the deputy committee, this law has not been raised. That they were not served with the impugned order of demolition. Their grounds have not been raised.
When is the date for section 5 before the appellate forum?
It's 12.
Your Lordship, notice has, just a minute, Your Lordship. Notice issue what? Your Lordship, we have filed, Your Lordship, we have not received any notice, I suppose.
We have received the notice.
Your Lordship, my junior can show that to Your Lordship.
Notice.
Your Lordship.
Yes, for you.
Date is 12th August 2025. So let it, I will not stop this. I'll not stay this. Let it be dealt with by the next circuit. In the meantime, if it is, unless the section 5 is allowed, we don't have a case. Yes.
Oblige, your lordship.
Learned counsel for the private respondent submits that an appeal has been preferred against the order impugned dated first.
It may not be that you have not challenged your, I'm seeking implementation.
Yes, yes.
I'm sorry. I'm sorry.
What did I say? Prior to that, learned counsel for the petitioner seeks implementation of the order dated, this is 1st February.
It's page 21 of my writ petition, 1st August.
Oh, the date is not very clear. 1st August 2017, issued by the Secretary, Municipal Council. Paragraph. Learned counsel for the private respondent submits that the said order has been assailed in appeal by the private respondent. An application filed under Section 5 of the Limitation Act is also pending since the appeal has been preferred beyond the statutory period of time. Paragraph. In view of this court is informed that date of hearing has been fixed on 12th August 2025. Paragraph. In view of the above, the matter be placed before the next available circuit.
Oblige, your lordship.
Next.
Number 11 WPA 290 of 2025.
I am for official respondents. Lordship, I am for the petitioner. During the course of the year, also, I will be filing the affidavit submission.
There are private respondents also?
Yes, sir. Just
What
getting
is the issue of? what is
Lordship,
the matter?
I challenge the order of the Tahsildar concern, your lordship, wherein Tahsildar concern has passed an order.
For demolition.
No, demarcation, your lordship.
Where is the order?
The order is that,
Let us do one thing. Please serve and come back. Let it appear tomorrow.
yes, sir.
Please file your affidavit of
Lordship,
service.
lordship, getting a form here. Yes, sir.
The official respondent is here. The private respondent needs to be served. Have you
Already
served?
served and I am getting a form.
Well,
lordship.
tomorrow.
Tomorrow. That
On
will be.
prayer of the petitioner,
Tomorrow.
the matter is
Lordship.
adjourned for the day.
Lordship. Oblige, lordship.
Item number 12. WPA 328 of 2025.
I'm there for the.
I am for the respondent.
Number 1, Mr. Kunsila, we are paying in person for petition number 2 and 3.
Yes.
They filed the report, lordship.
So for us, writ petition number 2 and 3 are concerned, we will take exception to the report.
Apart from that, my lord, I will be filing an supplementary affidavit.
The
leave. Tomorrow I will be able to file the supplementary affidavit, provided the leave is given to me.
Can you?
Let come in the next circuit, Munashim. In the meanwhile, sir can prepare.
Report submitted by the official respondents is taken on record.
One thing pinches me, my lord, should my son is posted in Mahavandar. I am in Port Blair. We have all three persons are residing together. My question, whenever I come to court, I have to leave my son at home. Or I have to take my wife and.
Appear virtually, sir.
Pardon?
Why don't you appear virtually? You don't need to come to court now.
Then the other cases are also there in the lower court where cross-examination is required.
Lower courts are not
It's being
compatible
done,
with
it's being
virtual.
done. Munashim, my senior advocate is an advocate who does the work in court. He's a.
It will be very difficult. It will
Please
be.
believe in that.
I know for the old days people, I mean, it's.
Yes,
so
sir. Yes,
difficult.
sir. Yes, sir.
Sir, my son is posted in Mayamandar. So he is not attending his job. He is living with me. Unless an adequate security is provided to him also.
Interim protection is there, Lordship. Not that needs to be extended to writ petition number 2 and 3 also. But kindly see the last order passed by His Lordship Honorable Justice Kaushik Chandra Lordship on 14th of August, Lordship, if I'm not wrong.
14th of August.
I'm sorry, Lordship, there may
But
be
in
some
July
confusion.
2020.
Sorry, Lordship, I'm sorry, Lordship. There may be some confusion with regard to dates. The first order passed by this court while admitting the report.
Petitioner, the first petitioner is not mentioned.
It's pretty, it's
So it should-
in
it's-
plural, Lordship.
No, it's in singular, but it's only petitioners. It doesn't say first petitioner.
The petition,
Respondents shall take steps to protect the life and property of the petitioner.
No, so, this, Lordship, that mean, Lordship, the writ petition 1 was given protection, Lordship. So for us, 2 and
That
3 are.
doesn't really mean that.
Well,
Very well, let this be extended to all the petitioners. Let me
I'm
clarify
grateful.
this.
I'm
one.
grateful. I'm
Let me
grateful.
clarify this. one.
My lord, I'm grateful. I'm grateful.
my lord,
Yes. Anything to add?
My son will be going to Mayabandar where he is posted. If security is provided to him there, then you.
I'll extend this order. to
My
all the petitioners, right?
My brother, my lord.
Taken on record, the first petitioner appearing in person seeks to use a supplementary affidavit in this matter. Paragraph. The second and third petitioners seek to use an exception to the report submitted by the official respondents. Paragraph, the matter be placed before the next available circuit bench. Paragraph, since interim protection has been granted. No, please strike it out, give a paragraph. By the order dated July 14, 2025, comma, this court directed the respondents to take steps to protect the life and property of the petitioner. Stop. Since there are 3 petitioners in the present matter, comma, such order be extended to all the
I'm
petitioners.
grateful. I'm grateful. I'm grateful. I'm grateful. Okay.
Next circuit stated. Next.
Item number 13. WPA 3/1/2025.
Lordship, I am
no,
appearing
no,
for the
no,
respondent authority, Lordship.
Yes.
This honorable court was directed me to give a temporary connection to the petitioner because petitioner was enjoying a connection in the year 2022. That was Revenue Department has demolished the building and they have informed over phone that since the building has been demolished, we have dismantled the meter. So once again, he has approached before this honorable court. He has filed a fresh application. And the direction which has been passed by this honorable court was that within 2 weeks, but petitioner has not submitted the certified copy of the order passed by this honorable court. Let petitioner may submit this.
Wait, you are appearing for the authority,
My
sir.
lord.
This cannot
Lordship.
be found. The authority is being represented by
Yes,
you.
yes, yes, Lord.
So they are aware of all the orders of this court.
Lordship.
7 days. Please comply within 7 days.
Lordship.
My lord, day before yesterday also, my learned brother appeared. He
Yes.
said
Lordship.
nothing was not okay. That was cured around 15 days back
That
and
is
intimated to
recorded.
them. I made a written communication to the authority that this is the interim order, though it was not required, my lord. The order is pretty clear. It says in view of the matter,
Let me give
respondent
them
shall.
7
Yes.
days more. They'll comply with the order within 7 days and file a compliance report with you.
As far as I have been appraised by my client, they are saying that they are making some of the other lame excuses, which actually doesn't have to do anything with the.
You have not challenged this order, sir.
No.
No.
You
This
have
is
two
just an
options.
interim order to
Either
reconnect.
to
That's
challenge or to comply.
Lordship.
So since you have not challenged. you
Let
left
7
it
days
to
time
judge.
may be granted.
7
Lord.
days it has to be compliant.
This is violation
Please file
now,
a complaint.
practically.
Absolutely. You can take necessary steps otherwise.
Yes.
The grievance of the petitioner is that despite an order passed by this court on July 11, 2025, directing the respondents to restore electricity connection of the petitioner within a period of 2 weeks from date. You've deposited the necessary charges and incidental costs, all that is over.
No, nothing was actually required from us by the authority. They came, they said that, no,
Subject
it
to
was
the
not
petitioner.
required.
It is required.
It is
Necessary
reconnection,
documents.
it's reconnection. If they ask.
They have applied a fresh lordship. It is not
Have
reconnection.
you asked for this amount?
No, they
Have
didn't.
you told the?
We will assess and we will inform.
Means everything within 7 days.
Yes.
10 days time may be granted.
7 days.
Sufficient time was granted to you, please make it within 7 days. Subject to the petitioner depositing necessary charges and incidental costs. Paragraph, it is not in dispute that the order has not been complied with till date. Paragraph, in view of the above, comma, the respondent authorities are directed to comply with the said order in its true letter and spirit within 7 days from date. Subject to the petitioner depositing all necessary charges and incidental costs.
If
As asked
intimated,
for- Yes,
if intimated to us, because it was not actually,
It is available in the portal.
by the authorities.
my lord.
A compliance report be submitted on the adjourned date. Paragraph, the matter be placed before the next, I don't want to dispose it of, let it be complied.
My lord,
The matter be placed before the next available circuit.
deeply request, I'm grateful, I'm grateful.
Item number 14, the PH 334 of 2025.
Lordship, here his application is pending before the authorities. So let a direction be given, we will consider and dispose of the application in accordance with law.
Lordship, I have submitted an online application on 4/3/2025
Yes,
and various honorable court of this
you are appearing for both the respondents, right?
Lordship.
Yes.
honorable high courts already passed various orders.
His application is
directing
with law.
to issue an electric connection.
Where is your application?
Page. That's not. Give me a minute. At page 12. Application dated 4/3/2025.
Yes.
Even after passing 1 month, they have not provided the electric connection. There are a number of cases, your lordship.
2 weeks. Within 2 weeks.
2
From
weeks,
date.
we will consider and we will dispose of in accordance with law.
Not dispose of, you'll give connection subject to the petitioner complying with all the formalities.
Lordship, in accordance with law.
Yes.
Yes.
Learned counsel for the petitioner submits that the petitioner filed an application before the respondents seeking electricity connection in his residential premises.
No, your enclosed land, you're telling us. That is in survey number 167, village,
In
Targan
his
village.
land on 4th March 2025. Stop. The application has not been considered by the authority till date. Paragraph, upon consideration of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the respondents to consider and dispose of the application filed by the petitioner dated 4th March 2025 and supply electricity connection to the petitioner, subject to the petitioner complying with all required formalities, comma, in accordance with law.
Obliged.
As is certified website. Next.
Item number 15.
Lordship, item number 15 in the year 2022 also they have filed a writ petition. All those things has been suppressed before this honorable court. Let me use my opposition, Lordship. I have all the document. I have received it.
You, in this matter, you said that they already have a connection.
Yes, Lordship. In the year 2022, they have approached before this honorable court. This honorable court has directed us to provide the electricity connection. But
And it was
despite,
provided.
yes, it was provided. I have already given the number that the petitioner is having one electric connection.
Please come back with an comment.
My lord,
I have the order passed by the Honorable High Court.
Needs to
They have,
needs to be on record.
yes.
Yes, what is your submission?
my lord, as per the instruction what I got from the lady, they don't have a connection as such in the said land. What we have mentioned in the petition, my lord, it's survey number
188.
188 in Bharti Nagar Hadbe, my lord. the lady is suffering and the lady has applied for an online connection in March, and till date the application is pending. There, so the respondent council, so it's from the respondent side should be clearly mentioned that there should be a remark given in the application, or there should be any rejection order. There's nothing to be given.
Let
And
them
they,
come back with an affidavit that will solve the issue.
and my lord, today
Only
they-
rejection will again bring you back to this court, right?
Yes.
So why are you asking for a rejection, sir? You can understand from his submission that it will be rejected.
my lord,
So let him come back with an affidavit in opposition. Let this court deal with it.
I would reply to that.
Right?
Yeah.
Absolutely.
Right.
If I give a direction for disposal of the application, it will be a rejection.
My
You
lord.
have to come back again.
And my lord, there was a report which my lord directed them to give today.
Yes, by way of affidavit, I will file everything.
By way of an affidavit.
My lord.
Learned counsel for the respondents seeks to use an affidavit in opposition in this matter. Affidavit in opposition be filed within 2 weeks from date.
Lordship.
Affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Okay.
The matter be placed before the next available circuit bench.
Obliged, Lordship.
Let it be decided once and for all.
Yes, ma'am.
Why go and come everything?
My lord.
Next.
In their undertaking, Lordship, what they are writing. Now he has submitted that upon this land, he doesn't have any, but page number 25 may kindly be seen, Lordship.
What is it state?
That no government land is allotted in my name from the, that I have no encroached land in Andaman Nicobar Island except this one,
Anyway, please come back with your affidavit.
Lordship.
My lord.
As such, I was objecting, Lordship. Otherwise, why should I?
Absolutely.
Item number 16, PRA on of 23.
Yeah, my lordship.
Then 2/25.
I am appealing for the petitioner, my lordship.
Appellant, yes.
Yes, appellant, my lordship. Here, my lordship, already this honorable court passed the judgment, my lordship, on 14/7.
Have you served?
No, my
Lordship,
lord.
it
Here, my
has
lordship.
not been served to the public.
I will serve, my lordship. There is a settlement has been done, my lordship, because this honorable court, while allowing my 138 application, my lordship, in the lower court, it was dismissed. But in the honorable high court, it was allowed. So there is a direction to pay 15 lakhs or 1 year punishment. Here we made the settlement, my lordship, instead of 15, we have negotiated for 13 lakhs. Already we received 5 lakhs. That I mentioned, my lordship. Let it be fixed on Friday, my lordship. On the day they undertake, that they will pay the remaining 8 lakhs also. I will serve, my lord. During the course of that, I will serve, my lordship. Let it be fixed on Friday, my lordship. They undertake that they will pay the balance amount of 8 lakhs.
Trial court?
Court below.
That they have not.
उससे म्यूट होता भी नहीं तुमको वही तो होता तुम
You're compounding.
Yes, my lordship. Because this court passed the order, my lordship.
Where is the order?
14 July.
Okay. You are for the respondent.
The state respondent, Lordship. It is 130.
Why state is not required? Who is the respondent here? Have you said?
I will serve, my lordship. During the course of that, I will serve, my lordship. This is first time it is coming, my
You
lordship.
have to serve the respondent, sir. How will you serve in course of the day?
By hand?
By hand, I will give the counsel. Yes, my
Yes,
lordship.
by hand.
Through the counsel, my lordship.
15 lakhs was the order.
Yes.
Friday?
Friday, my lordship. It can be disposed on.
Service upon the
Your lordship, I am appearing, your lordship, to be seen. Your lordship, this is the same matter, your lordship, it is relating to the noise pollution. Your lordship, conditional order was passed by the subdivisional magistrate, and I wanted, your lordship, because that is only a initiation of the proceeding when order has been passed. I just pray, your lordship, that the matter should be concluded. They have not challenged anyway.
Madam, you are invisible.
Right now, item number 16 is going.
You're in item number 16?
No, I think it's, ma'am is in 17, I know.
Yes, are you in 16?
No, ma'am is not in 16, 17. My lordship.
Since
is confused.
it is not complete, comma, let the matter stand over till 8th, day after.
Yes, ma'am.
17 is whose order is under contempt? 8th, your turn.
No problem.
Not by just. Registry may be directed to appeal to.
The contempt application has been filed. On the ground of violation of an order passed on April 8, 2025 in WPA 179 of 2025 by a coordinate bench of this court. Paragraph in view of the above, comma, the matter be released from this list and placed before the Honorable the Chief Justice, comma, High Court, comma, Calcutta for necessary directions.
My lord, registry may be directed to place that before.
Automatically.
Yes, yes.
Once this order is there, it will be done.
I'm grateful, my lord.
Must pass the format.
Lord, we see the adoption deed. Lord, we see at page 21, clause E. Based on this registered adoption deed, Lordship, the repetitions being the adoptive parents have applied before the registering authority for inclusion of their name on striking the name of the biological parents. The authorities.
You are appearing for the registrar also?
My lord, I will appear as a government leader. I can appear because
Yes,
I
you
don't
can.
have an instruction. As a government leader, I'm appearing, my lord, on behalf of all the respondents.
In the birth certificate?
Yes, like the child was given admission in the school with an undertaking that unless our names are in.
Absolutely.
Lordship,
Yes, what is the difficulty?
this.
Where is your application before the?
It's at page
Page 31, my lord.
31.
Application for this can be disposed of, my lord.
Simply the disposal will not do, not.
In terms of the order. You have to dispose it of in terms of the order. Page 21. The adoptive parents were given the liberty to apply before the authority for recording their names in the birth register.
My lord.
Should have been done by now.
Only on the basis of adoption deed, my lord, it's a registered adoption deed on
Yes.
instruction and submitting, they have to apply before the deputy commissioner. An application has to be submitted along with the adoption deed.
For what? What will the deputy commissioner do here? He has nothing to do with the adoption. Please see the order.
Ma'am.
Page 21, column 8.
That the adopted parents, being the first party, shall take necessary steps and all endeavors in accordance with law, for necessary correction in the birth certificate or any other documents with respect to the change of names of the biological parents who being the second parties hearing. The second parties will cooperate with this respective signatures and shall give their no objection when required or by the first parties for such correction over the birth certificate or any other documents pertaining to the adopted child. So, my lord,
Everything is enclosed with the document.
no objection.
I could have dealt with it.
My lord,
Not
if my lord
necessary.
sees the para 8, my lord, if it is required that no objection is also required from the first, who is given the biological parents.
And violence.
If
Shall give their no objection
Yes.
when required. When this is the order itself says that they have voluntarily relinquished their rights.
Yes.
Why do you require a further no objection?
Fine.
You don't. 7 days.
Great.
Please issue the certificate within 7 days.
Fine.
And
The petitioners who are adoptive parents of a child are aggrieved by non-issuance or aggrieved by the fact that the second respondent has failed to consider their application filed on 1st July 2025 for making necessary correction in the birth certificate of the child by incorporating their names as the parents of the child in place and stead of the biological parents. Paragraph. Heard learned counsels for the parties. It appears from the deed of adoption executed on 15th May 2025 that the petitioners have been declared to be the adoptive parents of the child, and the biological parents have relinquished their right, title, interest, and claim over the said child. They've recorded over adoption. It should be over the
Yes,
child,
no, yeah, I can have notice.
because that gives a different
Different
meaning.
meaning, absolutely.
In view of the paragraph, in view of the above comma, there is no reason why the second respondent shall sit over, there is no reason for the second respondent to sit over the application filed by the petitioners till date. The second respondent is directed to dispose of the application and record the names of the petitioners as the adoptive parents of the child in her birth certificate by replacing the names of the biological parents recorded therein. Incorporate the names of the petitioners. Therein, in terms of the deed of adoption,
Registered,
dated 15, yes, registered deed of adoption dated 15th May 2025. In the earlier part also, please record it as registered deed of adoption. 15th May 2025. Stop, such exercise should be completed within 2 weeks from date.
7 days.
Yes?
7 days will be very less.
That will be 2 weeks. The writ petition is accordingly disposed of. There shall, however, be no redress to cause such offence. There's another passed over matter waiting for you.
Mine.
Item number 5.
Number 1 में जो बैठा.
25.
Page number 31 is the notice issued by deputy.
That's subdivision matter,
Subdivision,
right?
yes.
He is the joint tenant. He wants to subdivide. The application is pending.
Mine.
Let it be disposed of. There was a notice issued also, but
Yes,
after that
ma'am.
it is still pending. It's-
Mine.
It has not been
Thereafter,
disposed.
24th February, last notice, my lord.
12th December 2024 was the date.
Thereafter, my lord, 24th February 2025.
So why isn't it happening?
No, maybe some, like, both the parties has to come or either of them. Huh? Maybe in the absence of either of the parties or something like that. Some other reason it has.
You have not
happened
impeded
because
the private respondent actually. In this matter.
that is the thing, my lord, whether she has
Name is there.
agreed for that.
What name is
No,
there? To
name is
member?
there, but
Maybe
she's
you've not
not before
impeded
my
her
lord.
this application. Anyway, let there be a
Direction will be
correction.
given, yes,
My lord,
2
notice
weeks.
to be issued to the.
Yes, upon
Yes,
notice
of
to both
course.
the parties, this and the owner,
Right.
the others.
Mine.
All
Adjacent
concerned and
plot-
record.
Yes, my lord. Adjacent plot.
Within 2
Yes.
weeks?
No, my lord. It takes some time, my lord, 1 month.
1 month. 1 month. The petitioner acquired title in respect of the in respect of a portion of survey number 245/35 as joint tenant thereof by virtue of a deed of sale, a registered deed of sale dated, the date is blank. What is the date?
It's registered 21st March 20
It's 21st March.
with the registration
It's
date.
April.
My lord.
April 2015. How can it be March?
21st May 2015, backside of the first page number 19, that registration date. 21st May 2015, it was registered.
Dated 21st May 2015. The petitioner applied before the
29 page number 29. Deputy Commissioner.
page.
29.
The first respondent on 1st October 2024 for subdividing the landed property. Stop. Notice of hearing was issued upon the petitioner.
If my lord
Who is
sees,
Jayalakshmi?
if my lord
Portal.
sees page number 29 and
Portal.
30, my lord, signature of Jayalakshmi is not there.
Portal.
In both the pages.
No, 29, her signature will not be there. It's an application made by the petitioner.
My lord, 30.
30 is annexed to this application.
My lord.
This is his application.
Proposal.
Jayalakshmi's signature will not be there. Notice was issued upon, notice was issued by the, don't write upon the petition, by the first respondent in this regard, but the hearing is yet to take place. The petitioner seeks expeditious disposal of his application and subdivision of the land.
My lord, may kindly mention the RC case, my lord, the top of
The notice,
the
page
RC case is
31.
the subdivision.
Statement in this regard.
RC proceeding is for the subdivision.
The top of the 30.
RC number 137.
Being, being RC number 137/GIS/2024/DC within bracket SA /page 31, you'll get it. /5517. Please add that. A learned counsel for the respondents seeks a month's time to dispose of the application. Paragraph in view of the above, the first respondent, right? First respondent will do it. The first respondent is directed to consider and dispose of the application filed by the petitioner within 1 month from date upon service of notice upon all concerned, including the petitioner, and granting reasonable opportunity of hearing to them, in accordance with law. The writ petition is accordingly disposed of. Urgency referred website.
Great.
Okay.